All right. Good afternoon, everyone, or good morning, depending on where you are. This is Curt and
Radbinsky.
All right. And we are here to talk about legal issues in the fire service in our weekly Fire Law Roundup. And Brad, go ahead, take us away. I'm going to deal with this.
Just a heads up for people watching today. There's some really cool issues that we're going to delve into. So really interesting issues, at least two of them. So stay tuned and keep eating your lunch or breakfast, whatever you're doing. So let's start with New Jersey. This is going to be a trend. If it hasn't, this is very much a big deal in New York, New Jersey. I'm sure there are other states. In New Jersey, a fire department has now been held liable for a sexual assault, child abuse that occurred 30 years ago. And if you're saying, are you sure 30 years ago is right? Yes. What happened in New Jersey, New York, I imagine some other states.
I don't think so.
Oh, really? Oh, okay. I mean, New York's crazy, but
I think it's pretty unique, but
wow. Okay. And in New York, it was Governor Cuomo who had his own problems with this, even fun. So, but nonetheless, not look, the Boy Scouts nationwide have been, this is what I'm saying, is they're going bankrupt, have declared bankruptcy. I'm defending a lot of these suits. I'll explain them in a second, but so what happened in New York and New Jersey, and that's I was thinking, since the Boy Scouts are pretty much bankrupt or declared bankruptcy nationwide, that maybe this is more widespread. In any event, New York and New Jersey enacted laws that basically revived the ability of a victim of sexual abuse up till any years ago. It doesn't matter. New York is like 200 years or something. It was a crazy time, but that any living victim can now pursue not only the offender, but also the fire department. There's some important language in here that I want to use for people who have junior programs. It is very important. That's why we're kind of highlighting this. In any event, they've been found to pay $300 and some odd $1,000 in liability. There was already a $4.7 million judgment years ago, but the guy defaulted. He was in jail. So everyone understands the person was convicted. The assailant was convicted already, sentenced to 10 years in prison. Now they go after the victim, but also the fire department and the city. And this is what's important. And now we're kind of quoting the victim's attorney, but the lawsuit focused on failure to properly supervise, failure to properly train personnel who were participating in the junior program. And the attorney said something that I really agree with.
Brad, I'm not sure that this is actually a junior program. I think that this person just brought the victim into the firehouse. And I agree with everything that you're saying. I agree with everything that you're saying, that junior programs need to be attentive. I'm not sure that this was actually a junior program.
There was a 12-year-old boy who was assaulted by the individual when he was a firefighter.
Right.
I guess that kind of makes sense.
In the firehouse.
In the firehouse.
And they felt like he was using the firehouse as sort of a place to bring them.
Oh,
that's my understanding. But so it could be. It just, all I know is there was nothing in nothing in anything that I read that said it was a junior.
Okay.
So that's why I would
let's kind of use that, right? And talk about this. There's two options though. So first, if it was an actual program where, juniors are brought in and, they spend the night or they're trained or whatever, then look, the fire department has an obligation to properly screen, to the extent you could do that, properly screen the members we're going to be dealing with the youth, but also to train, and I'll go further, also to have policies that ensure, like the one I always say, if you have somebody under 18 in the firehouse, there are no fewer than 2 adults in the same room. I prefer 3, but 2 adults. And for this, I define as an adult as 21 and over, not 18, because sometimes you get too close in age.
And just we refer to that as too deep leadership. That's the term. That was actually something that the Boy Scouts, I believe, developed, but they call it too deep leadership. And that's a good principle to have in the policies. Absolutely.
Yeah. And then look, now let's go the other way. If your other suspicion is correct, that they were just, this person was just bringing the 12-year-old boy in and sexually assaulting. Then in that, I'm kind of like, how the heck does the fire department lose? Right? Unless they had some knowledge, what would you train somebody in? So
I think that's the point, that we've got to be aware of the prevalence of pedophilia. And that when you have a certain member that is bringing, and this particular youth was not the only one that this particular gentleman was bringing into the station. There were a couple of others. He's only being sued by one of them, but there were a couple of others. But as a supervisor, if you're aware that one of your firefighters is bringing in a child that's not his or her own child into the firehouse on a regular basis, on an ongoing basis, and apparently there was at least 30 different instances where this happened. At some point, you've got to be attentive to these. You can't just ignore it.
Right. And look, we could make up facts. For example, hey, children, why don't you come see the fire truck, right? And we're using the fire truck, the firehouse, as a lure to get them in. And I suppose if the fire company, the fire department, knew that somebody was bringing them in to show them, and they were actively giving tours, and then, but wow, I mean, that's anyway, yeah, I get it. It's just crazy stuff.
It's mind-boggling. And you might know, I'm not sure if Perth Amboy is a career department, or is it a city with a career department? Is it a volunteer department? Or
I don't know.
I don't know the answer to that either. So but at any rate, it happened. The perpetrator was sentenced to 10 years in prison. And, on the earlier suit where the perpetrator was awarded, or the perpetrator was ordered to pay $4.75 million, somebody like that is judgment proof. He's in jail now. He'll never be able to pay, even if he pays $5 a week or $10 a week, whatever the court may order, never going to get anywhere near that. And so the next most logical party to go after.
Right, the fire department. But let's think about this. So intentional acts, this is why I love this. Hopefully everybody else finds this as interesting as Curt and I do, because we could hang up and keep talking about it. But, think about this from the liability, the insurance side. Now, and I say this and everyone always says, oh, there's no insurance, we're off the hook. No, if there's no insurance for something, which is what I'm going to throw out, you're still on the hook. You just are paying it out of your own pocket, right? So we don't know that happened, but what leads me to believe that the fire department maybe didn't know, or I don't know, is intentional acts are excluded from insurance coverage, right? Intentional illegal acts and criminal acts are excluded. But here it sounds as if it was the allegation sounded in negligence, that they negligently supervised. And that would not necessarily have been excluded from insurance coverage because they weren't doing the act. However, you could say, I've said this so many times for our longtime listeners, it's like the state park police who rapes somebody. This is a true case I had, who raped somebody, right, at the park, and the park gets off the hook, the government gets off the hook saying, listen, that wasn't as part of his job duties, because raping somebody isn't part of their job duties, so their employer doesn't have to pay. So to here, you'd think the insurance company and the fire department would say, hey, that's not our duty. Now, on the other hand, you and I have created well, wait a minute, but if you're constantly bringing youth in as a fire prevention program, it is your duty. Maybe it should be covered, or maybe not. I don't know. There's so many questions we don't have answers to. But
there is. And just to clarify, what we're talking about is the difference between suing the individual perpetrator who did something and the fire department for what we call respondeat superior, which is you're the employer, therefore you're liable. You're the employer, you're benefiting from the employee, you're liable for what the employee did. You can't recover for intentional acts under respondeat superior because it's outside the scope. Okay, but what they alleged here was that you were negligent in your supervision, and there's a whole line of cases. Negligent hiring, negligent retention, negligent supervision, and negligent training. All of those go in there. Those are negligence claims, and the scope of employment would not be a defense, right? Yeah. It should be covered. Now, the reason I'm going through that is I've got an interesting case I discuss a lot in my discipline class. the name of the case is MP versus City of Sacramento. And it involved firefighters who allegedly sexually assaulted a woman on duty. And the court said that we're not going to entertain the negligent supervision claims because it was outside the scope. And that would just be a way to get around it. So I think that's a California case. I'm not sure. I don't think it's going to be good law virtually anywhere else, but
except maybe
at
New
least
York, who's just as,
well, but they basically said, we're not going to hold the city liable, and we're not going to allow you to use those kind of claims to hold the city liable. So we didn't see that, at least as from what I've read from this case, as being an issue. But it's not an uncommon scenario, and it's something that we should understand.
Yeah, and really, just before we transition to Connecticut for a second, everybody should understand, if you're bringing youth in, I don't care for what purpose, you're doing it under the lure of fire protection or whatever, you've got to supervise them, you got to train them, and like we said, don't leave them alone with one adult. Two is even kind of scratching the surface, but we have to be careful. And I'm not saying that people don't deserve compensation. These 30-year-old suits, again, I have 13 of them we're defending in New York, and the assailant is dead in most of them, and there's no insurance coverage because it's 30 years ago, or 40 years ago, 50 years ago is one of them I have. I mean, you can't defend these.
Yeah, they really, you would have thought the legislature, and I would say this to any legislature that's thinking about this now going forward, you may want to limit the liability to the actual perpetrator and not to the organization. Because if it really, I think what most of these cases are is they're looking for vindication. And if you that's what you want vindication, you want to be, acknowledged as being the victim, then you can do that through an award against the individual. But holding the entity liable, it's the taxpayers. It's not the taxpayers today, not the taxpayers 30 years ago, 40 years ago, 50 years ago. It's today's taxpayers.
Right. I'm opposed to it. And people got upset at me for saying, oh, you're opposed to victims recovering. No, I'm opposed to the fire departments and the taxpayers paying. Okay, so I think we beat the heck out of this one.
All right.
Let's go to Connecticut, where, I've had this issue come up a lot. And in fact, I just had a similar issue. To the extent I understand what the issue is, I'll explain this. So here we have an elected official. She's the tax person.
Tax collector.
And apparently, and this matters, as a tax collector, she apparently sits on the municipal board as a tax collector. Now, I have a million questions, but we have a lawsuit filed by her. This is nothing but a lawsuit. She's suing under the First Amendment, basically saying that she's no longer, because she's being punished and retaliated against, she's no longer allowed to speak at these board meetings as an elected official. Now, I will tell you, I've had this issue and have had to give advice. But the issue I've had, and I'll explain the difference, has been where it's actual board members who are elected and to make policy. And making policy, you can't stop somebody from speaking. So she's alleged, which would be very legitimate if she was a board member with policy making and voting decisions. As a tax collector, I don't know what her, involvement is in speaking and et cetera. Is she allowed to? But if she has the right to speak as an elected official, she's going to win this. Now she also alleges, well, you're limiting my time to speech. I don't have a problem with that. But I do have a problem with you can't speak at all. So I don't know if you want to spend any more time on this than that. But if you have an elected official and you're mad at them, you can't tell them they can't speak.
Yeah, I think it's interesting. What I try to do is I try to provide a smattering of the cases that are out there so that folks understand that there's a range of cases that come up. This is just it's just one of those cases. I thought it was kind of not the typical case that we see, but they do happen.
I've seen this with fire district commissioners come up a lot, and they're so mad at the commissioner for doing something, saying, we're not going to allow you to speak. I'm like, you can't do that. So this type of thing does come up. But just, it's one thing. I got too deep in this when I read it. I'm like, well, wait a minute. I could see she can't speak about a relative. That could be a conflict. I was coming up with way too much, so I'm not even going to go down there. Where I do want to go, though, is in Flint, because this is a super interesting case. But before I review these facts, so that everyone understands, I want to go back a couple of weeks, or maybe it was last week time, just because we had a suit in New York with the special duty rule. And here's what happened, because we've got to revisit that before we talk about this. Again, this is just a lawsuit. It's not a decision. So it's important on what we think, what we think they're going to face here, because this is a big deal. This is public, right? So in New York, there was a fire, and the fire department responds, and the assistant chief or the chief says, "Oh, homeowner, we got this. We're going to take care of it. We'll put it out." And the fire doesn't get put out, all right, timely enough, allegedly. And the court kicks out the case, dismisses the case early on because there was not a special duty. And now you're going to see, everyone will see where my mind is going to go before we talk about Flint. And what the court said is, listen, first of all, in New York and many other states under like a public duty doctrine, et cetera, you need to establish that there was a reliance, a one-on-one conduct, which resulted in reliance. I'm not doing the four perfect test, right? Summing it up so that the homeowner would have to rely on, in this case, the fire department to perform a duty, and that the fire department would have had to know that if you told someone you were going to do something and you didn't do it, there would be damages. Like, for example, don't jump, we're coming to get you, and the person doesn't jump and dies in the fire because we never got him. The reason I'm bringing that case up is because I think that is exactly these facts. And in that case, what the court said is, listen, there was no special duty because the fire was already well involved. They were just performing a duty anyway to respond to the call. That duty is owed to the public at large, not to the specific individual. So we are dismissing the case, said New York, because there's no one-on-one duty owed. Again, I'm repeating this, but it's going to be important here. The fire had already been well involved. They're responding anyway. So here, now with that background, everyone will understand my thought on this, which is we have a fire that was underway. Two boys were in the fire, and it's very interesting as you read the facts. So the allegation was the fire was mostly out, which I only got near the end. Mm-hmm. These two firefighters are assigned to do a primary search. They claimed they did a primary search. The allegation is they didn't, and it wasn't until the secondary search that the bodies were discovered. Right now, we're missing a little proximate cause, which is had they were discovered earlier after the fire was already out, right, that they could have been saved. But you don't even have to deal with proximate cause, which we'll talk about, if you look at duty. Isn't this, I ask you what your thought is, isn't this case which says, listen, had you not lied and conducted a search, right? Or because you lied and conducted a search, you breached a duty. Well, yeah, but no special duty or public duty. What, right? Is this any different than saying, look, the fire was already involved. At this point, it was almost out at the time they were alleged to have not conducted or lied about conducting their search. How is there a duty at all owed one-on-one to the kids nonetheless, right? The kids didn't rely on them. The father didn't not do something, or the mother not do something. I don't see how this doesn't get dismissed immediately for no public doctrine, duty doctrine, or no special duty.
Yeah, I agree. And but I think there's a bigger issue in this case that wasn't really mentioned in the complaint. I'm a little bit surprised because I've been following this for a while now. The two firefighters shortly after this that missed the two kids on the primary search were initially suspended, and then one resigned, the other was terminated, or they both ended up resigning. Okay. In addition, the fire chief was terminated. Okay. And there was a question about competence and whether or not they actually did the search, were they trained to do the search, and all the stuff that goes along after this. There's also, my understanding is there's a racial component to this that was not in the case.
That's clearly the undertone.
And that they didn't diligently, the firefighters who were white didn't diligently search. And I want to speak from my personal experience. when you're looking for a body in a primary search, we're assuming that you've had a real fire, not just a little, smoke in a building, but you had a fire.
Hard to miss.
You can't find them there. Everything is the same color. Everything is the same color. You can't see it. And I sympathize with the firefighters. I sympathize with the victims as well, but I sympathize with the firefighters. I've been there. I can't say I have personally missed a body, but I can tell you I have been the incident commander where we missed bodies on the primary and we only found them on the secondary. And it's hard from an incident commander's perspective to have that happen. And it's even harder. I've watched my people really upset.
They didn't look under a bed, or they grabbed something that didn't feel like a body.
I've gone in. I went in on one in particular, stands out in my mind, like clear as day. It was as clear as day. I think it might have been as a battalion chief. It was my first fatal fire, not my first fatal fire as a firefighter, my first being the incident commander. And they missed them on the primary. They missed them on the initial secondary, and the people were insisting that there was somebody in there. So we sent my best team in there. Actually, my brother's crew went in, and my brother found them. But he called me in, and he said, "I want you to see this." And you could not make out the person. You could not. You just couldn't see him. And then once you saw him, like there was ceiling and debris and everything over them. It was a woman and a girl, and her head, she's actually on the toilet. Her head was on the toilet, and there was ceiling and everything draped over her and everything. But my point being, this is not something that is in any way easy, and it is understandable that it happens.
If they missed it. Now here the question is, did they actually do it?
Well, and that's apparently there was some sort of a partition in the room, and they were on the other side of a partition. But be that as it may, okay, the challenge here is you've got all this stuff, public outrage and anger, the termination of the firefighters, the termination of the fire chief, and all of that, which probably, I mean, maybe it should have happened, maybe it didn't. I can't say, okay, but you've got all of that sort of in the background, and now we have this lawsuit that's alleging that the firefighters were negligent. And I agree. I think that the public duty doctrine should prevail in this, and the case should be dismissed. But I want to go beyond that. Even if they don't have the benefit of the public duty doctrine, they should prevail on they could prevail on the negligence aspect. Okay, that they weren't negligent. They didn't breach a duty of care, because it is such a challenge. That's number one. And then the other one is you mentioned it going in here,
Causation.
Proximate cause.
Yeah.
How do you prove that if they had found him on the primary, that it would have? Now, in this case, the brothers, I believe, did survive for a brief period. I'm not sure if this is the case I'm thinking of, but there was a case where the fire victims, and I think this might have been, they survived for a couple of days. But it might not be. It might be a different case I'm thinking of. So, but that would be one example of where you could show proximate cause if they had survived for a couple of days and expired. You say, well, an extra 10 minutes might have made a difference.
Right. And what's weird here is, though, you're kind of near the end, you say, because the fire at the Pulaski residence had already been knocked down at the time the two defendants were ordered to conduct the search of the second floor. I stopped there. I'm like, wait a minute. So if the fire was already knocked down, this is so late in the game. I suppose you could say, why didn't you conduct a primary search before? But wait a minute, telling a fire chief what is safe, what is worth it. And apparently they were told, or they should have known, the allegations made that these people were in the house. But if fire chief gets there and says, listen, I'm not sending anybody in yet until, maybe because it's building construction or extent of involvement, whatever it was, I don't understand why. Well, you wouldn't focus a lawsuit on that, right? Because it's totally a fire chief's judgment. But if the chief then waited until we're almost in knockdown overhaul mode, how are you going to prove? I mean, come on, the fire has been totally going for all that time? I just don't see how they ever would prove it. And I don't want anyone to think, because I'm always afraid of you and I being accused of anything. We're not saying that we do or don't sympathize with, I mean, we did say we would sympathize with a proper search if one were conducted, right? That it's easy to miss, but we're not saying that it's a good or bad, that we don't understand the victim's feelings, right? Or the relative's feelings, but as a legal analysis, right? Doesn't mean that something wasn't wrong, you're not winning. And, this is a big deal. I don't know if there's special duty or public duty doctrine in Michigan. I have no idea, but
I think there is. I think Illinois, this would be a tough case in Illinois. The Illinois Supreme Court a few years ago abolished it. So that would be one less protection that firefighters have in Illinois. But in Michigan, I believe the public duty doctrine is still in effect.
In Washington State, they would probably win too, or, could get past it. So, okay. I love this next case. I was so intrigued. I did a bunch of research. I did that because I'm in New York State, and I will explain that. So we have Louisiana, because I went to Tulane for law school. So we have firefighters who are simply claiming that we're being ordered to be fingerprinted. And we've been threatened with termination if we don't agree to it. And so now they're suing for a violation of Fourth Amendment rights, basically saying it's an unlawful search and seizure. And if the attorney for that case is watching, I apologize for what I'm about to say, but have you done any research? Because I spent, 20 minutes and I did some, and it turns out this little court called the United States Supreme Court in 1985 said that fingerprinting is not a violation of the Fourth Amendment because it's such a minimal intrusion anyway, and it has significant importance. And then if you didn't like that, there's 40 or 50 cases that are cited in various federal courts, including New York and many others, and as recent as last year, that say that fingerprinting is valuable and is a minimal intrusion, and requiring it as job employment is not unconstitutional. So this, unless they know something, U.S. Supreme Court and many other federal Court of Appeals, including the Second Circuit, I don't know what tree they're barking up, but here's what I want to say. In New York State, in fact, we did a lecture on this at my conference last year. In New York State, New York has a law because of the United States Supreme Court. They enacted a law that says you may not, as a condition of employment, take biometric, identification. You cannot require that, which, by the way, let me throw out, is very interesting because many states have something called a length of service award program, right? And many states, there are many employers who use what we call finger in, finger out, right? Put your thumb on here and we'll tell you whether you showed up for the call or whether you clocked in, clocked out. In New York State, you can't do that. You cannot. And in fact, if anybody wanted to sue their fire department in New York State, they could say you're only giving me credit for showing up if I give you my fingerprint. And New York State has not allowed that. But New York State is extremely unique. And I read a law review article. I was so intrigued with this. I read a law review article, and apparently New York State's the only state, at least as of a couple of years ago, that has that prohibition of, taking a biometric identifier. And on behalf
of everyone listening, I would tell you I'm not surprised. We are not surprised.
Right.
You are unique.
It's good to live in New York and be a practicing attorney. What can I tell you? But the reason New York did that is because I presume the U.S. Supreme Court said fingerprinting is not a violation of your rights. So you lose. I'm guessing you lose. I'd love to get egg in my face, but
I would think if I'm confronted with this scenario, I've got upset clients. I think the only other avenue is going to be some sort of a collective bargaining where you're changing the terms and conditions of employment and you didn't negotiate it. It's a unilateral imposition. But I'm not seeing the Fourth Amendment.
I'm not.
Part of this.
I'm not. So we won't beat that one up anymore. But if the short is, unless you're in New York State, if you want to require fingerprinting, that it's valid. And the courts recognize that it's valid to make sure, especially in firefighting, you're not a terrorist, you're not an arsonist, you don't have a criminal history. It is valid to do. Now, I do have a concern. Would it be valid to say we're using it for time to show that you're right? That might be a little different if maybe I'm trying to stretch here, but what if the purpose was not to do a background check or anything other than we want to use it, for example, to show attendance, right? And as opposed to you're signing in or clocking in, could that be a intrusion into their rights and their violation of their Fourth Amendment rights? I still think it's a stretch, but the facts could change things. What are you using it for? That's, I didn't want to leave that totally out there, but as a general matter, if anyone's worried about doing a fingerprint background check as a condition of employment to get a job, or, every year we're going to run a background check, make sure you haven't been convicted of, I don't know, child pornography or something, or, something like that. I don't have a problem with that. I think they lose. Okay. Speaking of child porn, do you want to say
speaking of child porn and the Fourth Amendment.
Yeah, this is great. Now, this is such an easy case, but in short,
this is the Kentucky case. This is the case this is the the Kentucky fire lieutenant's conviction on child porn charges upheld.
Yes. And the challenge here was that the seizure of the laptop and the and I'll summarize the facts in the important facts in 2 seconds. But the allegation is that the proof you used to convict me, which was child porn on a laptop, that you illegally searched the laptop. So here's the important part. This was a laptop. There was child porn found on it, which was ultimately used to convict him. The court held, as many courts before it have, is listen, this was a department laptop issued to an individual, and the chief of the department, although it wasn't his personal laptop, right? The laptop belongs to the department. The chief was authorized to give consent to search the laptop. Now, we're going to talk about this a little broader to give people, this is a big topic, right? But effectively, look, this is no different than a landlord says you can search apartment my tenant's in. It's no different than a husband saying you can search my wife's stuff. If there's ownership, you can grant consent. So that's the challenge. This same challenge I have seen defeated, just like it was here, and at least 9 other cases I found very similar. But there's hundreds like this, not necessarily child porn in a laptop, but locker cases, right? Where the chief says you can search the lockers, or an employee's desk. Yes, we gave you a key to lock it, but that key is not to protect you. The courts say to keep us out. We have the right to enter your desk, to enter your locker, to enter whatever, and we then can consent to a police search of it. I would still, however, be very clear to everybody by issuing a policy saying you have no expectation of privacy whatsoever in anything we give you, loan you, allow you to use or access, with only one exception that I made, at least my department, which was unions, saying if we've given you a file cabinet, we are not going into any of those file cabinets. You have an expectation of privacy. But I know I'm a little off topic, but
no, but I do want to speak to that too, because before this is, I think, is an interesting case for those who are really concerned about Fourth Amendment privacy issues in the firehouse and different things. Very, very important. But I think what we got to start with is the basic question. I asked this in my class quite a bit. Is it possible for a firefighter to have a reasonable expectation of privacy in what's on a fire department computer? The answer to that repeatedly by courts is yes, they can. That's not really even the issue, but yes, a firefighter can have. The real question is, does a firefighter under these circumstances have an expectation of privacy? And you have to look at, is it shared, is it not shared, is it password protected, etc.
And you just get notice,
right? And then the most important issue, and it's the same analysis whether you're dealing with lockers, closets, anything in the firehouse, but the most important issue is, do you have a policy? And this is one area where you absolutely positively need to have a policy. And I don't want to get into all the reasons why, but just trust me, you need to have a policy. And apparently it seems like this fire department may not have had a policy, but the court nonetheless upheld the search because they said that the chief had the apparent authority authorize. And I'll let you get into the details of why that was, but.
Yeah, and they also, well, and more importantly, they not only had the right, but they also had probable cause, right, to conduct this search. And the probable cause was kind of funny. I hate to be this way, but it's kind of funny. So, you know, he gets accused and interviewed across the street at the police department of, you know, I presume the interview, which was like a 10-minute interview, was basically, hey, you know, there's been this allegation that you have child porn on. He runs back from the firehouse and starts deleting stuff in front of a bunch of people. I'm not saying everyone's intelligent, but he starts deleting a bunch of things from the laptop or whatever. And so the person who witnesses it calls his friend, of course, who's a state trooper, reports this, and then the dominoes start to fall. But the probable cause is you came back from the police department who just talked to you about the issue, and you're now deleting things quickly on your computers in front of people. That to me is pretty good cause. I would have no issue with the search, either on the right of privacy, because I think there is no expectation of privacy here, and on the probable cause ability, because that seems like probable cause to me. But that's really what happened.
Yeah, well, I think I would kind of slightly look at it a little differently. I would say he has an expectation of privacy. He has, because they didn't have a policy. It was his computer. He had an expectation of privacy. Okay, the chief took the laptop back, which the chief had the right to do, but the chief didn't search it. The chief, you know, basically took it back. Okay, the chief gives it to law enforcement, and law enforcement. Now the question is, did the chief have apparent authority to authorize the police to look at it? Right. And the court concluded they did, that the chief had apparent authority. And so it's not saying, they didn't even get into whether or not under these circumstances, did he have a reasonable expectation of privacy. It was more about, did the police act in good faith and believe that they had the right to search it because the chief told them they could search it? And they said yes. The court said yes.
Right. And, you know, so this goes back to what expectations do you give somebody? What, right? And they're going to weigh it. What is a policy? Policy wins against everything.
If they had a policy, this would have been an easy case, simple case.
Right. Yeah. So, you know, then otherwise you're going through what are the facts and evaluating the facts, and what did someone say to you? What did they put in writing? What do they like you said, you gave two big ones, right? A password is really the biggest. We allow you to lock somebody out. But on the other hand, I will bet you that yes, but we have a third-party administrator who can override every password just in case. So, you know, everybody should have a policy. And frankly, your policy, lockers, desks, filing cabinets should say we can search them at any time. And most important, not because, yes, we can search them at any time, but most important, so they don't bring stuff into the firehouse. We can't stop people from doing illegal, creepy things, right? But at least don't do it in our damn firehouse. Anyway, I think that was such an interesting case. That really should be our showcase case. It's a great case for so many reasons.
Yeah, and I would encourage folks to read it, read the decision. It's a pretty easy read. One of the things that's a little unusual and confusing is that the firefighter who was charged here is the son of the fire chief, which I think complicates it a little bit, but it also, you might say that maybe gives the chief a little bit more authority to authorize the search as opposed to you know, someone who was not related to him. And I think from what I read, it appeared that the chief gave them the laptop, assuming that it was going to clear his son. You know, obviously it was mistaken. So.
Yeah. And unfortunately, this is one of so many cases with, you know, things like this. And we've had two this week. You know, I won't even joke about, it's child porn week.
We're not immune from it. I think that's the best way to look at it. And sometimes we think that we are, but we're not. And I don't think we have an excess, but we're not immune from it.
Right. And I really think that departments, and additionally to making clear you have no expectation of privacy on anything, but also saying, you know, do everything you can to keep things out of the firehouse, and not, going back to the other case, not allow the firehouse to be a place where people can escape to. You know, one of the things, this is off topic, but that we see a lot are affairs at the firehouse. You see a lot of people having their affairs there. it's bad for so many reasons, right? It creates so much discord and disharmony and loyalty issues. Oh, I know the wife, and your wife comes to lunch, but I know you're having an affair here. I mean, but people use the firehouse as a shelter. I've seen things in lockers that shouldn't be there. I've had cases where people are storing long guns in lockers, you know, and because they think nobody will find it. It's my private place. And you've got to make clear, don't bring that to the firehouse. Otherwise, you could face a failure to supervise, you know, type suit when something bad happens to somebody in your firehouse.
Sure.
That's it. A great week of stuff.
Yeah, that's going to wrap it up. And I should remind people earlier, but please subscribe to our channel. We're closing in on 1,000. We need about another 100 people to subscribe, but it's a big deal for YouTube. It puts us into a new category, which would be really helpful to us to help get the word out. So, you know, if you could help us out by subscribing, we'd appreciate it. Please click like and share. And hopefully we'll see you again next week on another edition of Fire Law Roundup. All right, Brad, thank you. We'll see you soon. And your class is coming up, right? We got your 2 weeks.
Yep, right? Our conference is coming. We'll see you and finally get to eat dinner as opposed to, you know, looking at you online.
Yeah, sounds good. I'm looking forward to it. All right, that's it. Thanks.